Take it off. Oh, sorry, sir. Thank you, sir.
Yes.
I was about to say, so I started by observing a moment ago or before the break that no steps were taken centrally to address risk, and instead much was left to the judgment of individual doctors. So we heard from Dr. Winter, as you may recall, that the absence of centralised guidance meant that there were major variations in treatment and care. And so he said, sir, you'd be utterly bemused by the different way in which 10 patients could be treated by 10 different doctors. I mean, it was astonishing, and something that will surely come out of this inquiry is the great variability of care. So an absence of urgent action when risk became apparent, and even then, as matters proceeded, no central or authoritative guidance, but instead letting haemophilia clinicians get on with the job in the way that they saw fit. So no central standard setting. We have observed throughout our written submissions, my clients have observed their shock at the response to risk that we've seen, but importantly, before I come to my next point, in our submission, it's important to observe that this was not a situation where there were rogue doctors, one or other doctors making problematic decisions in a particular case. This decentralised, ad hoc, variable decision-making without central standards and the diminishing of risk was something that was endemic. It fed through the whole of the practice of haemophilia clinicians. And so inevitably, there were differences in approach and problems emerging from that. In addition to the doctors and the difficulties that we see emerging because of the absence of central standards, there is, of course, the question of the pharmaceutical companies that I've already raised. My clients, in their opening, observed that for them, they were concerned whether there were incentives from pharmaceutical companies for doctors or haemophilia centres to offload what were cheap and, in the event, infected products despite risks. My clients' concerns have become more concrete, having heard the evidence, in particular, for example, and by way of illustration only, the meeting at Heathrow Airport and the evidence of Professor Tudenham when he spoke of lavish entertainment showered on doctors by pharma in the expectation that they might gain influence, and the funding of research that might be affected, the outcome of which might be affected by conscious or unconscious bias. So we have the clinicians, no standard setting, minimising of risk. We have the pharmaceutical companies, again minimising risk, as they inevitably would, given the huge profits to be made. And if not improper relationships, certainly relationships that give rise to concerns about corruption that I will come to in one moment. So loading off dangerous products in a context where there are no central standard setting. And indeed, as you heard, sir, the pharmaceutical industry only took action in relation to Factor 8 when compelled to do so, and when they appreciated that not taking action might cost them more in revenue than taking action. So you'll recall, sir, that when compulsory screening was introduced, it was resisted in the first instance. And when introduced in the mid-1980s, you'll remember Armour, for example, insisting that there was no risk inherent in Factor 8, albeit at the same time voluntarily withdrawing unscreened products. So, as I've indicated, right through doctors with the pharmaceutical industry, with minimising the risks involved, and no overarching standard setting or regulation. The third cohort or institution, of course, were blood services. They could have properly been expected to have played a leading role in apprehending and responding to risks, but instead we were told, you were told, sir, in a presentation from counsel to the inquiry, that the blood transfusion services were a fragmented and disorganised shambles. So again, no central standard setting, no guidance, no unified national regulatory systems. So bringing that all together for the moment, having regard to the framework that I invited you to consider, the absence of risk, the response of the clinicians, the pharmaceutical industry and blood services is such that those important rights guaranteed in the instruments I took you to were wholly undermined and violated. The right to life, the right to bodily autonomy, the right to health, the right to dignity, and the right to non-discrimination, all engaged, and if any regard had been taken to those rights and obligations, and there plainly wasn't any regard, urgent steps would have been taken, and they were not. That's risk, sir. I'm going to move now to patients. I don't think, sir, that the inquiry has heard from many, if any, infected or affected persons who've said that they were treated entirely properly by clinicians and services responsible for their care or the care of their loved ones. Certainly, from the perspective of my clients, based on their own experience and the evidence they've seen and heard, there was a universal or almost universal ignoring of the rights of patients to information and to give or refuse consent to treatment. Patients and their parents or carers were not warned about the risks associated with Factor VIII, including of the enhanced risks associated with particular products, commercial products, for example. Instead, patients were largely marginalised from their own care. As we've said in our written submissions, the approach of clinicians was epitomised by paternalism, doctor knows best, and this idea, this notion of clinical freedom. Doctors' freedom to make their own choices as to treatment without regard to the wishes of patients or the interests of patients. Misinformation was widespread. This included, as I've already alluded to, the minimising of the extent of the risk posed by Factor VIII, and the right to information about their health status in the case of patients, including my clients, was not respected. Again, all matters addressed by the human rights instruments that I identified and took you to this morning, sir. So products were chosen and administered without proper consent. We heard about what that means from the medical ethics expert group. That means agency, autonomy, and liberty. Again, core interests reflected in the human rights instruments that I took you to. Risk assessments were made without the involvement of patients. No systems were in place to empower patients in the making of treatment choices. The response to the identification of risk arising from the link between HCV, HIV and Factor VIII, and the experiences of those infected and affected by HCV and HIV were both affected by stigma. Clinicians and policymakers were resistant to the notion that innocent people with haemophilia could be affected, while people with haemophilia who were infected, like my clients, faced stigma and marginalisation. As Robert said in evidence, the association with homosexual men, sex workers and drug users made it very much a disease nobody wanted to be near. High levels of paranoia, bombardment of tabloid stories, presented as the worst disease associated with bad people. And the characterising, as he has said, of people with haemophilia as innocent victims did nothing, and if I may say so respectfully, does nothing to remove stigma. It merely reflects the stigma attaching to HIV and HCV and dumps blame on marginalised communities. As we've said, that stigma was institutionalised, bigotry was widespread. You'll remember the words of the Chief Constable of Manchester, people with HIV swirling in a cesspit of their own making. So inadequate engagement with patients, no information, no consent, and affected by stigma. The fact that there were these distinctions between the good patients, people with haemophilia, and the bad patients, sex workers, drug users, homosexual men, meant that there was a division of services, as you heard from Robert. So the whole approach of the patient being in charge of their treatment was lost, notwithstanding that had they been directed to specialist HIV services, they would have experienced very different care. But the bifurcation of those who had contracted HIV and HCV meant that my clients, along with many others, did not secure the specialist services that international human rights instruments insists they're entitled to access because of stigma and prejudice. My clients make the point, as they have already, that everybody is deserving of respect, care and empathy wherever, whenever and however they were infected. But importantly, had that approach been adopted during the AIDS crisis, the likelihood is that people with haemophilia would have received better care. So the reduction of stigma, the taking away of stigma, respect for the dignity of all people who contracted HIV, in all likelihood, would have helped everybody, including those who had contracted it through blood transmission, but who were deprived of access to specialist services because of the stigma associated with that cohort, the dirty cohort. We also saw evidence, considerable evidence, of haemophilia clinicians objectifying patients and treating them with a lack of empathy. You'll recall Professor Ludlam writing to Dr. Krask in 1980, accepting an invitation to serve on the Hepatitis Working Party of the UK HCDO, in which he stated that he was very conscious of the almost unique group of haemophiliacs we have in Edinburgh because they've never received commercial concentrate and therefore, as you're aware, they are useful material for a variety of studies. Useful material. So the dehumanising of haemophilia patients, the objectification of them, is utterly stark. We see that too in the observations of Dr. Ritzer and his reference to chimpanzees and the need to find a human cohort to administer and test concentrates on. Again, a dehumanising and an objectification of real-life people. Also evidence, including, as occurred in my client's case, of samples being taken from patients and then stored and tested, sometimes for research purposes without consent, evidence of a failure to secure ethical approval for research for which such research would have been required. Research was undertaken anticipating that injury might be called, see RITSA. Tests were taken, HIV and HCV tests, were taken from patients without consent, and where positive, there was often delay in communicating results, creating risk for loved ones and others. So systemic practices right across the board, depriving patients of their bodily autonomy, and those aspects embraced, those rights embraced by the right to health, caught by the human rights instruments that we went to this morning. As to my clients, each of my clients, they experienced many of the matters that many of the experiences I've just identified. I'll say something briefly about them because they're obviously important. I won't have time to recite everything, but I'll make a few observations. Mr. AK was infected with hepatitis B as a child. He was later notified in 1990 that a blood sample had been taken in August 1980, 10 years before. No consent. Test taken, sample kept, not notified until many years later. He was given no warnings or advice about risks associated with factor VIII, nor was there any discussion with his clinicians about the choice of factor product that might be available. And he, to the best of his recollection, he has never, in the whole of his adult life, been given a choice of blood clotting treatment. He tested negative for HIV on the 3rd of August 1982. His positive result was 18 December 1984, so he was infected at some point during that period, after we say the link between factor VIII, hepatitis C and HIV was known. He did not ask whether he wanted his blood tested for HIV, and he did not know about it until he was told after the event at a hospital appointment.
Well, he couldn't have known about the August 82 event, could he? Because by then there was no test. That was obviously a retrospective test.
Yes. Sorry, I'm not sure I'm understanding that, sir.
Yes. There wasn't a test for the presence of HIV until the HIV virus had been identified and isolated. That was done, at least definitively, in 1984, in April. It was announced in the United States. It was after that, very shortly after that, that there was a test for the presence of the antibodies to HIV. And this is my understanding. And it was that test which was then applied to a number of serological samples which have been taken from patients. If there was a test done on blood which is dated August 82,
it wouldn't have spotted it.
It was obviously one of the samples that had been taken. It was sitting there waiting to be tested for whatever it might be tested for at some stage in the future. That was the point I was making.
I see.
So it supports your argument that he didn't know.
Yes, I
understand
the distinction. Yes, I'm sorry. Yes. So the blood was the blood had been retained, so they were able to test it, presumably, having identified the date on which it was taken. And I've got lots of nodding from the members of the public. Thank you. They're giving me a lesson on testing. Thank you. You can come up here if you like. So the sample must have been retained, and as you've said, sir, tested later on once testing had become available. So he was able to deduce that he contracted HIV during the period of 1982 and 1984. 1984 being the date of the positive test.
But what I understood from your client's evidence was that he didn't know that a sample had been taken for the purpose of testing at some remote time in the future for something.
No. I mean, there was, as you've said, there was no consent given to testing at all, no consent given to the retention of samples. These were all done without the knowledge or consent of indeed all of my client group. This was a feature of the treatment afforded people with haemophilia and the transmission of viruses. As you just alluded to, and I was about to say, he wasn't asked whether he wanted to be tested, and he didn't know he'd been tested until after the event. He was told in a way which was unempathetic, asked if he wanted to know his status, said yes, I'm afraid you're positive, was the answer. No explanation about what the diagnosis meant, no counselling or information to help him manage and understand the infection. And as he described it, you may have his statement there, I don't know if he described it to me or in his statement, but the experience was a lonely one, as he describes it. He had very little support at the outset from outside the haemophilia centres, and he makes the observations, as you may have picked up, sir, that the two positive experiences he had in the NHS mainstream services the two positive experiences arose from contact with people outside the mainstream haemophilia centres. So a counsellor and a young doctor on secondment, the only positive experiences he had. Otherwise, like my other two adult clients at Material Times, the support he obtained was outside mainstream services, body positive, Terence Higgin trusts, mainliners, and they ought to be given credit, those early organisations, early NGOs operating in a hostile environment and putting out a hand to support those who had contracted HIV, whatever their circumstances. The advantage of that, as you've already heard, is that they were specialists. They knew how to access support services, and they were able to assist him. As to Paul, then, Paul, again, he received no advice or information about the risks of factor VIII, and nor were his parents. By November 1976, he'd been given US commercial factor VIII. By 1977, he'd developed acute hepatitis B as a result of infection, and he and his family were told they'd been unlucky. He was told of his infection with HIV in June 1985 at a short appointment to briefly discuss one or two results, he was told. He was not prepared for that appointment, given any support, and nor was he given support afterwards. He was told that he would probably only have a couple of years before developing symptoms and a few years to live. And he was told to keep his diagnosis secret because of stigma. And as he says, the stigma in the mid-1980s through to the mid-1990s was one of vile hatred and fear. The impact on him, like Mr. AK, was devastating. But again, he assumed he'd been unlucky because he had read the 1 in 1,000 story, the Haemofact leaflet, authored by Dr. Lee and Dr. Kernoff, and it was just bad luck. Eventually, Paul was referred to an HIV clinic, that is outside haemophilia support services, whereas he said his experience of health services improved significantly. He met gay men, drug users, and much of the advice he received came from organisations like Terence Higgins, Body Positive, Mainliners and similar organisations. And importantly, he was able to provide support to them too because of his knowledge. He was told he had HCV in 1992, but not to worry about it because the HIV would kill him first. As to Robert, again, neither he nor his parents were told that there was an increased risk of infection associated with factor VIII. He was not aware at any point being asked, or his parents being asked, whether he wished to revert to cryoprecipitate. He was diagnosed with HIV in 1985 when he was 18 years old. And again, as with the others, he was not informed in advance that he was being tested for HIV. He was told of his HIV diagnosis when he called to make an appointment to see a haemophilia doctor, and if he hadn't done so, he anticipates he wouldn't have been informed until sometime after that. And just before I come to Mr. A.H., the youngest of my client group, I emphasise, as my clients have, and I've emphasised more than once, but it's important to do so, that organisations like Terence Higgins, Body Positive and Mainliners were concerned with ensuring that their human rights, their fundamental rights and their dignity rights were protected. And there was a complete distinction between organisations like that and specialist HIV services supporting gay men and drug users, a complete distinction between the care in specialist services and haemophilia centres. HIV clinicians were collaborative, warm, in complete contrast to the patrician, distant attitude of those clinicians in HIV centres. The last of my clients then is Mr. H. He was 7 when his parents were informed that he was HIV positive, and his parents were warned, his parents were not warned, forgive me, weren't warned of risk at any time. When they were told of Mr. A.H.'s infection, they were told they should prepare for his death. He was in fact told inadvertently, or negligently, aged 12 by a supervisor at the hospital of his diagnosis, causing him considerable distress. Mr. A.H. was a child, as I've said, and while in his early teens, so still a child, he developed AIDS, causing physical illness, but also considerable mental distress. And as with others, his family experienced the negative consequences of the stigma attached to AIDS, that is, while he was still a boy. So their experiences were typical, unique to each of them. Each experience is unique, but they were typical to the extent that no consent was sought, no information was provided, testing and treatment occurred without the provision of information, without empathy and support, and without access, save when they sought it out themselves, to specialist services. I'm now going to move to my next topic, sir. I suppose I ought to say, although I think it's obvious, if I were to round up the observations I've just made about my clients, I would say again that those experiences fit comfortably within a human rights model, and one can test whether the response of the state through NHS services met the standards set by those human rights instruments by looking at the provisions in them. So my next topic is care and support. Leaving aside for the moment the direct contact with haemophilia centres, the lack of empathy, the lack of support, counselling and so on, care and support generally provided to patients following infection was wholly inadequate and largely depended upon the awful financial assistance schemes about which we've heard. Those schemes were largely, or the creation, establishment of those schemes were largely motivated by the need on the part of government to acknowledge public sympathy, but at the same time to avoid hints of admission of legal liability. Even with the inadequacies in those schemes, there was evidence of resentment amongst some operating in this area, resentment that even those schemes had been established. So you'll remember Professor Lee describing herself as irritated by the establishment of a funding scheme because it suggested liability, she said. And as she put it, the idea that we would give somebody some treatment that they knew would cause harm is frankly ridiculous. And it's actually quite hurtful for those people, those many people who cared for patients. It's our submission, sir, that there can be no doubt now that that is precisely what happened. Products were administered that were known to cause harm, and her assertion that it's frankly ridiculous to suggest otherwise simply reveals her own lack of empathy, in relation to these matters. She's irritated by the prospect of support for these patients. That absence of empathy and indeed self-awareness can be spotted elsewhere. You heard, sir, of the Daily Mail test from Mr. Stevens, trustee of the Macfarlane Trust, in deciding how to calculate the sums to be paid, asking himself, how would it look to the readers of the Daily Mail? Barely credible. Significant problems with the financial schemes, as you heard in great detail, and I'll only touch upon a couple of points. First of all, the institutional arrangements meant that they lacked independence. It seems that trustees hadn't appreciated what their obligations were in charity law, but in any event, the arrangements lacked independence from government. The Macfarlane Trust, for example, seemed to think that they were simply administering a fund for the Department of Health. In addition, the way in which these organisations, these funds, carried out their functions in relation to intended beneficiaries was often arbitrary, hostile and demeaning. Decisions were often made without any principled basis for determining outcome. Again, as you heard from Mr. Stevens, Macfarlane Trust, he told you, I was simply, as it were, on my own, a free agent, doing, giving, making such decisions, giving such judgment as seemed to be right, really, as an individual. Utterly arbitrary, utterly unprincipled. We also heard that potential beneficiaries were kept at a distance. We heard about the postbox, so as to avoid having to make contact directly with patients or proposed beneficiaries. Applications were routinely required to be processed through local haemophilia centres, resulting in an element of postcode lottery. And importantly, in the experience of my clients, was that awards were made often following demeaning means testing, about which there was widespread resentment. The trustees of the Macfarlane Trust, in particular, were derisory, disrespectful to intended beneficiaries. You'll recall the reference to the great unwashed and correspondence between Mr. Clark and Mr. Stevens, along with other examples explored in evidence of grossly offensive and contemptuous remarks. It's almost impossible to believe. Certainly, and this is apparent just from the short observations I've made, the trusts managed their funds and managed applications without generosity, without compassion, without empathy, and in the absence of a culture of kindness. My client Paul described in his witness statement, but I could find other examples, that seeking assistance from the Macfarlane Trust was tantamount to a begging bowl. He had to justify any application, and all funding was linked to rules and restrictions that didn't fit his lifestyle. Experienced financial hardship, and you heard from Robert too, that he avoided, unless absolutely impossible to do otherwise, applying for one-off grants because he disliked the system so intensely. So again, no support, demeaning, absence of dignity, absence of access to proper care and services, all embraced by those human rights instruments, and no evidence of compliance, and indeed utter disrespect and an absence of concern and respect for the dignity of all of these human beings. So my last subject, sir, is accountability. And I just have a few observations to make about this. So I will, I'm happy to say, finish within my allocated time. So accountability. Relevant, of course, more generally for the inquiry, but also relevant for the purposes of the instruments I've taken you to. They're all addressed to states. Where does accountability lie? And I want to just say something about that. Almost all of the key actors involved in the matters that have been explored were employees or agents of the state. So that's easy. The state bears responsibility for their acts. Those acts were largely the acts of the Department of Health, but also other NHS bodies and clinicians. But as to private actors, the pharmaceutical companies in particular, we say the state also bears responsibility for their acts in providing and supplying without warning and appropriate protections, factor 8, because they had not put in place, that is, the state had not put in place, proper apparatus or institutional arrangements regulating the activities of pharmaceutical companies, so ensuring the safety of commercially produced factor 8. So far as the instruments that I took you to earlier this morning, sir, responsibility in those circumstances would fall within the state because it's their obligation, first of all, to protect against risk, wherever that risk comes from, so long as it is known, and the state obligations under the specialist conventions, like the UN Convention on the Rights of Disabled Persons, address in particular the need to ensure safe access to health services, as indeed does the Covenant. So the Convention plus the UN instruments make clear that there is an obligation on the state to ensure safe access to appropriate services, and the state can't escape that responsibility by delegating any obligations to private companies. Instead, it's their duty to put in place proper institutional arrangements, and they didn't. So the Department of Health, which bore institutional responsibility for the safe delivery of health care, did not, for example, set standards, as I referred to earlier. No specific clinical advice was imparted in the early years to haemophilia-centred doctors. No broad assessment of risk to be fed down, but instead, as I've indicated, doctors were left to sort it out themselves. Advice was on an ad hoc basis, often downplayed risk and was often wrong. You'll recall the evidence of Dr. Wolford, that she relied on the UKHCDO to do the job of working out risk and dealing with it. And when she did step in, it was to underplay risk and impose a threshold for risk, which was wrong and out with the requirements of human rights law, but out with ordinary clinical standards. So she said that she insisted upon firm microbiological, biological or virological evidence rather than that was the second word I practiced this morning, after cryosipitate, no, I can't remember that one either, epidemiological association. So she was not concerned, she said, with simple association, but rather firm microbiological or virological evidence. So a playing down of risk, no setting of standards, and no clinical guidance imparted centrally. We also heard about the foot-dragging approach to self-sufficiently, again, inexcusable state failures. There was a lack of genuine interest for self-sufficiency, as we heard, so funding and capacity was not made available. And the importance of that cannot be overstated. I just pluck out one piece of evidence. That's the evidence of Professor Tudenham, who said that the provision of home-produced concentrate would have reduced the number of HIV-infected patients so that we would have had half or less antibody-positive cases that we have now had factor VIII sufficiency been reached in 1977. So the importance of self-sufficiency cannot be overstated. And as I've already said in relation to regulatory oversight accountability issues, we heard that the blood security or the blood services were a shambles. No proper, finally, in relation to accountability, no proper or robust regulatory or licensing arrangements were in place, so pharmaceutical companies were able to operate without proper restraint. Since, as we've heard, the industry is worth billions, there was inevitably going to be very little incentive for the industry to regulate themselves safely. Why would they? That ought to have been secured through a robust regulatory regime. Instead, the licensing regime was weak, and the relationship between doctors and pharmaceutical companies, as I've said more than once, and you've already heard from others, unhealthily close and even corrupt. As to licensing, you heard from Professor Sir Michael Rawlins, a member on the Committee of Safety of Medicines, advising licensing authorities on that committee from 1979 onwards. He said he had no recollection of any discussion after he joined of either the source of blood donations for factor concentrates, for example from prisons, high-risk areas, or any discussion about pool sizes and their significance. So no discussions in that body that ought to have been advising on licensing requirements and regimes. He said that there was a power, we could see no reason why there wouldn't be a power, to attach conditions to a licence, wide-ranging conditions to a licence. So, for example, requiring manufacturers to provide information about pool size, only use pool sizes of a certain magnitude, or restrict the sources of blood donations. Those could have been imposed, he said, but they didn't consider it. Instead, assumptions appear to have been made throughout. As I've said, and I'll finish on this in the hope that I don't completely bore you to death about it, but it is, again, important. I referred you to the expression covert bribery. That was something about which we heard from, again, from Sir Michael. Evidence of practices, as I've said, excessive hospitality, sponsoring doctors to go overseas, but in addition, perhaps shockingly, treating clinicians, appearing before his committee to advocate on behalf of commercial companies. So that's everything, sir, except not letting government and ministers in particular get away with it. So this is my last point, stigma and ministers. Much like social contagion, stigma can be eliminated, sir, by challenging it, by putting positive public messages out there, respecting and celebrating those communities affected, but the state did nothing during the 1980s and 1990s to address stigma. Stigma obstructed the identification of risk, safe treatment responses, impacted on the care of patients, and was utterly undermining of the dignity of my clients and the communities affected more widely. This was primarily a government issue, and government ministers should not be let off the hook for not addressing it. And this is not a party political issue, it's a governance issue. But just by way of example, the only example I can find, there may well be others, Lord Fowler told the inquiry that at critical times there was a complete lack of engagement in relation to the AIDS crisis on the part of the Prime Minister, Margaret Thatcher. She was also, he said, difficult to work with, and personalities can matter in addressing social issues. But the reasons she gave for disengaging or not engaging are evidently in part because of her own homophobia and the stigmatising that she engaged with in relation to those infected with HIV. So as Lord Fowler told you, her own concern on this was actually a rather odd concern. Pausing there, not odd, just typical of a homophobic and stigmatising response. But in any event, her own concern on this was actually a rather odd concern. It was that if young people read the warnings, they would be introduced to things that they'd never heard about, which might well have been the case. But the implication was if they heard about it, if they'd be introduced to them, they would race away and do them. They would race away and become homosexual. So prejudice, stigma and ignorance runs through the whole of this history, we say, and it's important to observe, and you may feel able to observe, so it's of course a matter for you, that that stigma hasn't evaporated. That stigma is still there. My clients still experience it, and there is still secrecy and cover-up among some parts of the community because of the knowledge of the impact of stigma. So stigma and human rights I end with, and those are my submissions unless there's anything in particular I can help you with. I'm a little early, but I hope I won't be criticised for that.
No, not at all. Thank you very much indeed. You've given us an interesting and slightly different perspective as you set out to do. So thank you.
Thank you, sir. Thank you.
Ms. Richards.
So if we take a break now until 2 o'clock, and then we have the Vice Chair of the UK Thalassemia Society at 2.
Yes. So 2 o'clock, the Thalassemia Society.